Hello, my name is Mark Sandell. I work for Unite the Union as an organiser, and I'm speaking today about grievances and disciplinaries. Take down any notes you want to and ask me any questions in the live session. So, to start with, how does British law see employment of a worker? Well, British law sees the relationship between a worker and a boss as an equal contract. You sell your labour and they buy it at a price. This is obviously a nonsense. We need to eat, and the boss wants to make more out of us than we make, and pay us to do it so that they can make a profit. They have the ownership and the power, and we need to feed and clothe ourselves, so that's why we go to work. As a worker or an employee, you can take your boss to a civil employment court if they breach your contract. But these civil employment courts, called employment or industrial tribunals, are incredibly weak and take a very long time to take action, up to a year. There is also a gateway process which makes it quite difficult to get a case heard at an employment tribunal, and a penalty effectively if your case doesn't meet a quite high bar, quite a high test of whether it's a genuine case or not. An employment tribunal will look at how you have been treated by your employer and will decide whether it's been a fair way under the contract of employment or not. Your contract is meant to be an equal contract between you and the employer. As I said, you're selling your labour, they're buying it to obviously ultimately make a profit. What's written in your contract is very important in terms of your employment rights. You do have the legal right to a written contract. However, many employers don't give you a written contract. In the written contract, it should tell you whether you are a worker or an employee, and I'll come back to that in a minute. It should also tell you your rate of pay. It doesn't have to tell you, but it does sometimes tell you how many hours you're expected to work and other contractual obligations, start time, finish time, things like that. But many contracts don't say these things. What it does have to tell you is your rate of pay. So if your contract is broken by your rate of pay being changed, you're paid less than your rate of pay on your contract, you do have a case of what we call breach of contract by your employer. And change of the amount you get paid is indeed something you can challenge through your contract. However, an employer can change your contract if they want to by either finishing it in the time that you have allotted in your contract, so they can say in 4 weeks' time your contract is over, and then they can offer you a new contract on worse pay and conditions. This has been used by British employers recently. Many employers, British Airways, a bus garage company in Manchester, Weetabix, British Gas, and what it's called, this ending a contract and rehiring you on a worse contract, is fire and rehire. Now, this practice is unfortunately legal under British employment law, but illegal in most of Europe. If they're not doing that, however, and they try to change your pay without your agreement, then you can challenge it. And the way you would challenge that is through a grievance, which I'll be talking about in a minute. The issue with pay is that it's a contractual condition and they should pay you what they say they're going to pay you. And that is something you can challenge, as I said. Other parts of your contract, it does depend on whether the law sees it as a fundamental or a important change. So if they asked you to do a slightly different job, it's probably not a breach of contract. If they move you to a different workplace, it's probably not a breach of your contract. So some things in your contract are protected, other things are not. But it is a right to have a written contract from your employer. Workers and employees. If you are working for someone and there are certain conditions, you can be treated as either a worker or as an employee. In some circumstances, companies try to pretend that when you're working for them, you're in fact self-employed, working for yourself. This has classically been used by employers like Uber, who pretend that their drivers are simply independent and self-employed. The test of whether you are self-employed, an employee or a worker, the simplest test is when they pay you, do they take tax from your pay before you are paid? If they take tax from your pay before you are paid, then you are almost certainly a worker or an employee. If they give you a wage without tax and national insurance taken away from it and expect you to do that, the chances are they're treating you as self-employed, in which case many of the things that you've learnt about for workers' rights and employees' rights won't apply. There are lots of other conditions that can show that you're employed, and it's sometimes an issue of dispute, and Uber have recently lost a case in the High Court in the UK to say that the people that work for them are actually workers working for the company and not self-employed. But, as I say, some employers will pretend that you are self-employed. The best single test is, do they take the tax and national insurance from your wages before you are paid it? So if you are a worker or an employee, you do have certain what we call statutory rights under British law, and they can be enforced by a tribunal, which in most cases is not going to help. But the fear of a tribunal does sometimes make an employer think twice. And the tribunal will see if someone has been dealt with fairly. The government has a body that looks at employment rights called ACAS, A-C-A-S. You can find it easily find it on the web. And ACAS have guidelines for the treatment of employees and workers by employers. And these guidelines are quite important because many employers use these guidelines in their own procedures or refer to the ACAS guidelines in the procedures they have for discipline and grievances. So it is worth looking at these guidelines. Most large employers will have their own policies, their own written policies on grievances and disciplinaries. So obviously, if you are in the situation of being disciplined by your boss, or if you want to take out a grievance, it is important to look at their own policies and probably also to look at the ACAS policies. But you'll find that in many large firms, the ACAS policy is the same sort of thing as your company's policy. Now, when we're talking about grievances, we need to think about the rights that you have as a worker or an employee. Many of those rights are not well protected, and many things can be changed without it being a breach of your contract. A few things can't, like your hourly rate, your pay rate, but there are other things that are covered by British employment law which don't have to be in your contract but are still protected for you as a worker. So the minimum wage is a wage that is set by the government that has to be paid. It does depend on your age, and some exceptions to it do exist. If you're an apprentice, you're training to do a job. But in most cases, the minimum wage applies. It's called the living wage by the government, and it sets a rate that has to be paid. Now, there is no way around this for an employer. They have to pay the minimum wage to everyone of the age that it defines. There are protections for maternity and paternity rights, the right to take time off when you've had a child. There is sex discrimination laws, race discrimination laws, disability discrimination laws, Health and Safety at Work Act, which I think you covered on a different thing, and also a minimum number of holidays that you have to have, paid holidays, and also a sort of basic bottom line of how many breaks you should have. I'm not going to go into the details of those because in this session we're talking about disciplinary and grievances. You can find out about these on government websites or the TUC's website. The TUC's website is, the TUC is the organisation of all the unions in the UK, the Trade Union Congress, and you can find out from other unions as well. But these rights are protected by law, so if your employer is breaking the race or sex discrimination laws, you can challenge that in a grievance, and it doesn't have to be in their own policies, although often it will be in their own policies. If you are going to challenge an employer on these things, it is always best to do it first through their own procedures, through their grievance procedures, so that you can show that you have challenged them before it goes any further, and that will be a good thing to have shown if it does become a case that goes to an industrial tribunal or a legal case. So I'm going to briefly explain how disciplinaries work and then talk a little bit more about grievances. A disciplinary is when your manager decides that you have breached your contract or broken a company rule or policy. Again, with disciplinaries, there should be a procedure in your workplace that you should have access to, you should be able to ask for and see, and there will be steps in that procedure which will usually have a time factor. So the disciplinary procedure will usually say, a disciplinary will be dealt with in good time, that, there will be a time scale between having an interview with your manager and them telling you the result. And these time scales should be in the policy. Again, if there isn't a policy or if the policy is not clear, then most employers will refer to the ACAS Code of Conduct, which you can find on the ACAS website. And the rights should include the right to be accompanied in any formal interview. So if your manager is saying, I'd like to have a word with you, then you can't have someone with you. But if your manager invites you to come to a meeting to discuss a disciplinary matter, you should be offered the right to have someone with you. That person can be your trade union representative if you are a trade union member, or it can be a friend or colleague. So they should give you the option of having someone with you. And if they don't offer you that, you should say that you are asking for it in writing to show that you have asked for someone to accompany you. There should be a proper hearing, and there should be notes taken of that meeting, and you should see the notes of that meeting after that meeting to agree that they are accurate. If they are planning to sack you, to end your job, they should tell you that when they invite you to the interview. So you shouldn't be invited to an interview for a disciplinary thinking that it's a minor thing and then afterwards discover that you've lost your job. They should tell you that you are facing the sack when they invite you to the interview, the disciplinary interview. You should also have the right to appeal against the decision of the manager, and that appeal would usually go to a higher manager, someone above them in the company, and their policy and procedure will tell you what the grounds for an appeal would be. And again, the ACAS Code of Conduct is going to say quite a lot about the right to appeal. So those are the basic rules if you are being disciplined by your company. A grievance is when you as a worker are challenging a manager or the employer about the way they have treated you. And the basis of a grievance can be anything from a breach of employment law to a breach of your contract to something that might be against company policy. So if the company has a policy on bullying and harassment, you might challenge a manager on the way that they've been treating you. Now, in a grievance, again, there should be a policy in the company, and you should be able to find that policy. And if there isn't a policy, it will be the ACAS Code of Conduct that will cover the grievance procedure, which you should, again, look at before you put in a grievance. As with a disciplinary, there should be a hearing, there should be the right to be accompanied, There should be an agreement on what's been said in the meeting in terms of the minutes or the notes that were taken during the meeting, and there should be the right to appeal. However, a grievance in most companies' policies and also in the ACAS Code of Conduct is usually an individual thing. And that makes it quite weak for the worker, for yourself. The much more powerful way of doing a grievance is to get other workers who are affected by the same issue to come together and put in what we call in the trade union movement a collective grievance. This is where you might say in a form of words what you're unhappy about and get many workers to agree and sign that they have a grievance about the same issue. So the best place to start with an issue that you are concerned about at work is to find other workers, colleagues, who feel the same and experience the same as you. If you can get them to work with you and put in a collective grievance, you're far more likely to get the company, the employer, the manager to move. You can support that grievance, or even before you put in that grievance, you can get other workers to join you in small acts that show that you are not happy. And it's one of the things that is done in many organising campaigns by trade unions, is to find an issue that people are concerned about, to get them to work together on it, maybe meet to discuss it, come to an agreement that the thing that they want changed is X, and then take some activity to show that they are unhappy with the way they're being treated. So that might be something as small as all wearing the same colour on a particular day. It could be wearing a badge. It could be just having a protest. And obviously it could, it should also involve thinking about whether in your battle over this thing, you might need people to join together in a union, a trade union. And a good trade union will be able to support you in the activities you want to carry out. It is always more effective if you have unity across a group of workers over an issue and you want it changed, to put in a collective letter or collective grievance or petition. On your own, it is quite easy for a manager to ignore you. It is quite easy for the employer or a manager to manipulate the situation and even to get rid of you, to sack you. If it's a whole group of workers, which the company are reliant upon to do the work they need doing to make a profit, then obviously it's going to be harder for them to take action against the whole group, especially if that group is organised and sticks together in a collective way. So a collective grievance is a powerful thing to do. There isn't much guidance on it on the ACAS Code of Conduct. There won't usually be anything in the company policy on it. But if you all put in a collective grievance, you can then insist on the management hearing the grievance from each one of you, but you're still doing it as a collective group. I'm going to stop there because I've probably slightly gone over my time. I've covered grievances and disciplinaries and the ACAS Code of Conduct. I'm very happy to answer any questions you have, and I'm sure there'll be more detail that will come out when those questions start being asked. Thank you very much. I'll see you on Saturday.